Nous passons au troisième exposé de cet après-midi, le caractère politique.
We'll move on to the third presentation, the last character of the asylum in the case law of the EU. It will be delivered by Catrinel Brumar, a lecturer at the University of Bucharest. Thank you. Hello to everyone. First, I would like to tell you that I have given some minutes from my time to a colleague so that we have enough time for the discussions at the end. As for the status of the asylum in the case law of the European Union, I would like to make a few comments at first, which hopefully will be useful for our analysis. In the history of international law, a refugee is a person expelled from his community of origin since ancient times until the 19th century. The right to refuge was granted to those people who were expelled from their countries in an illegal manner. Between the two world wars, in the Geneva Convention as well, a refugee is a person that is left without his citizenship or he is denied protection. The denial of protection is a threat to the person, but only serious behaviors were followed by such a denial. The reaction of a state before a person's behavior was related to the legal text.
Travaux préparatoires de la Convention de Genève indiquent également, sans ambiguïté à mon avis, que le
preparatory works are rather ambiguous to my mind. It shows that the refugee status actually points to a refusal in the state protection, which places the individual in a situation where it is impossible to benefit from such protection. The definition of the refugee cannot encompass all the events that could determine an individual to run away from his or her own country. Lack of protection is an absence of the protection from the country of origin, and that refusal to be protected by the state is not prosecution, it's an impossibility. In the EU, we see a reinterpretation of the classical definition of the refugee. That plus also bringing a reinterpretation of some of the clauses in the convention, which is expressed by the opinion of the High Commissioner for Refugees. The two forms of protection, the refugee status and subsidiary protection, are actually brought together by the concept of international protection. Two aspects are essential given the seemingly opposite directions. The first refers to the notion of persecution in the eyes of the EU, where we don't have a definition of persecution. We know that a refugee is a person who fears something, fears persecution, or a person who, after an act of persecution, is found outside his or her state of origin and is prevented from going back there. The community regulations, the EU regulations, show that there should be some severity of the act, of the severity of the persecution, which will lead to assessing the refugee status. For instance, a violation of the human rights, the fundamental human rights. In the draft article regarding the responsibility of the states, we find a definition of severe violation of the norms with no possible derogation. Moreover, the other phrases that are used in the EU regulations in order to describe an act of persecution beyond severe or repeated persecution and an accumulation of measures points to the fact that the state, the state which authored, from where the persecution stemmed, does not comply with the norms. In the same time, the EU regulation lays out that the persecuting state cannot or will not offer protection to an individual. So the notion of a refugee refers to moves from the impossibility to benefit from protection towards the responsibility of the state to grant this protection. We should also note the uniformization of the status of the beneficiary of international protection. This uniformity suggests a certain change in the vision regarding the refugee status. The political character, the link with a community where an individual will express himself or herself as a member, and the humanitarian vision. But this humanitarian vision is coupled with a reduction of the status given the temporary benefits. We are speaking here about a divorce between the individual and the community where he or she could have found an expression as a member, and where he or she could have benefited from everything that community could offer. An individual in search of another community. This individual is somehow a person in pursuit of temporary protection. All these elements bring some sort of contradiction. So the European Court of Human Rights asked to make a decision between one of the two, either of the two visions. In the court's decisions that tries to clarify the status of the individuals found in such a situation, we can see some possible interpretations. In one of the cases, the court states that the situation should be appreciated based on the capacity or incapacity of a state to provide protection to individuals. these individuals are found in a persecution situation. To the extent to which the European Court excludes proportionality from the analysis, we have the decisions B and D of the Court, European Court of Human Rights. I'm sorry, says the speaker, there is a recommendation of the High Commissioner of Human Rights, meaning the states should verify the moment when they assess the application for the refugee status. In the case of refugees that committed severe crimes or acts. So in such a situation, the court records to the legitimacy of the recognition of the refugee status. In such a case, we reject the humanitarian character, but not the political character. Someone who perpetrates a morally sanctionable act, but this person is an asylum seeker too, cannot benefit, however, from the refugee status. As for the interpretation of the notion of prosecution, the court is prudent and speaks about the humanitarian character of the measure. In cases Y and Z, the court found that it is a right that is essential, and I have in mind religious freedom. We can speak out about an act of persecution if such a freedom is not complied with. And the court requires or calls for the individual analysis of each case and finds that states should not have a disproportionate reaction. On the main topic, in X, Others, and Schäfer, the European Court of Human Rights speaks about the disproportionate or discriminatory character of the sanctions in case of asylum seekers. Which requires for the assessment of the state. So a state should assess each situation the moment when the human rights standards are involved. Because these standards cannot go below the accepted and applied standards of each and every state. There are some elements that are recurrent in the court decisions, in what the court deems an illegitimate behavior of the state of origin. The case law of the European Court of Human Rights that somehow maintains this ambiguity between the political character and the humanitarian character of the refugee status, together with the closeness of the statuses that results from various types of international protection, as well as the inclusion of some new elements in the definition of the refugee status, moving it from the impossibility of the individual to benefit from some rights and the responsibility of the state in securing protection is linked to the opportunity of maintaining this concept of refugee. This concept which is somehow deprived from its essential features that were initially determined. Even if this is a temporary status that does not formally exclude, neither does it invite to the naturalization of the individual or integration in a community, and I have in mind a definite integration of the individual, perhaps the humanitarian character will be better substantiated. Or why not? It would be better to bring together the two visions in order to define the international protection that is offered to the persons found in need, the persons who need such a protection. But the idea or the hope is that the benefit of this protection should not last too long. That at the end the beneficiary will go back to his or her country of origin. Thank you. Thank you. Thank you, on the one hand, for having summed up your paper, and on the other hand, thank you for bringing some, to speaking about the same topic as the previous papers. As I said, Roberta Mungiano is not here.
And not read the whole text, because there's no reason to give more time to somebody who's absent than to those who are present, but to try and read the most typical parts of it in order to give you an idea of what she wanted to tell us. My outline, writes Roberta Mungiano, is concerned with EU policies on asylum and border control, with a particular focus on the measures adopted in the context of the so-called European refugee crisis. I suggest a change of paradigm in order to address the present and future crisis and investigate to what extent this is possible under EU law. I understand protection as both in terms of domestic protection categories, but also with regards to means of migration control. And I understand deflection as any measure inhibiting lasting forms of access to a territory. Migration control functions by managing the inflow, presence, and outflow of non-citizens on a state territory. By virtue of the migration control system, a person is allowed to be accepted or she is deflected from a territory. Protection serves a different function from migration control, and it is not a subcategory of the former. By virtue of protection, aliens who are in need are accorded protection benefits. If the person is found in lack of such entitlement, protection is not granted and rejection is performed by the state. Differently from other systems of asylum in the world, aiming at incorporating and supplementing the Geneva Convention regional context, the CAS has been created as a flanking measure in the process of European integration. Protection was subordinate to deflection by making the functioning of asylum instruments, importantly the Dublin system, functional to the goal of securing the external borders of the EU. Gradually, there has been the construction of the CES, which has been always conditioned upon the subordination of protection to deflection, as just mentioned, but was also dominated by the need to harmonize member states' legislation as to procedures and substantive recognition of protection status in order to reduce secondary movements of protection seekers within the EU. The Stockholm Programme stated that the CES should be based on higher protection standards. The logic of subordinating protection to deflection still informs the border control and asylum system as it appears now, but the developments of the CES points toward a potential adoption of a logic of more protection, or we can say at least there is a momentum for it. Today, the perceived refugee crisis has triggered a search for solutions where the recourse to measures of deflection is accompanied by a rhetoric of border protection. What is searched at the EU level is to make the system of border control and asylum to function efficiently. It is a search of efficiency with deflection. It is difficult to reconcile a system of border control and asylum which works efficiently with the respect of the rights of the individuals. Efficiency of the system and protection of the right of the individuals do not necessarily go hand in hand. Currently, to maintain in place a system which the EU struggles to make efficient, there are several examples in which the right of the individual is sacrificed to the alleged efficiency of the system of deflection. But is deflection really effective to make the CES effective and bring solution to the present and future refugee crisis? Deflective measures have not prevented or discouraged people from risking their lives to reach Europe. Deflection does not seem to be the answer, and focus should be on the better implementation at the member state level of the already adopted measure of EU asylum legislation. One for all is the example of the malfunctioning of the hotspots in Italy and Greece. An empirical study shows that reinforcing the external borders will not necessarily make the system more efficient, but that present and future migration influx to Europe should be addressed by focusing on protection in terms of supporting the national asylum systems of the member states, and by ensuring that EU asylum law is correctly implemented to address the reception and humanitarian challenges experienced by asylum seekers in the EU. The question is at this stage, to what extent does it find legal basis in the treaties? Article 3 TEU and 67 TFEU, measures with respect to border control, asylum and immigration, are functional to the creation of an area of free movement, and the EU does not have in itself a protection mandate. According to the treaties, as said earlier, measures on border control, asylum and immigration are compensatory measures. This is very well expressed by Catherine Costello. Other than a reference to fairness and respect for refugee rights, there are no positive formulation of what aims EU policy should pursue. Beyond the political and the moral, it is safe to state that the better implementation of the already existing measures on asylum and border control finds obstacle only in those safeguards of member state sovereignty, as for instance in border control Articles 72 and 74 TFEU. As to the possibility of creating humanitarian channels, the treaties do not give a clear formulation of a protection mandate which would support such instruments, although the visa code include a provision of visas which can be issued on humanitarian grounds. Living up to the protection obligation should not be the annoying obstacle to the so-believed efficient functioning of the deflection system. Conversely, protection issues should be addressed first, and this will give direction on how to deal with border control issues. In this way, it will not mean that border control will be subordinated to protection, but it will mean that the further changing of the border control regime for the sake of its efficiency will be informed more on the EU and member state protection obligations and capacity to receive third country nationals and process their asylum claims. legal basis seems to allow this to the extent that concerns a better implementation of the existing legislation, taking into account member states' sovereignty safeguard, and also EU legislation allows the issuing of humanitarian permits to enter the EU territory. So I've cut a little bit the text, but I think it gives the gist of what Roberta Mungiaro wanted to tell us. Thank you very much. Nous avons donc
On the agenda, we have reserved 10 minutes for debates. The good news or the bad news is that we are flexible with the agenda, which means that there won't be at 6 any meeting of the committee, which gives us more time to discuss.
Come with a comment or a question should raise their hands. La présidente.
Non, non, non. Dis seulement qu'à partir de...
The organizers know exactly what we are talking about here, because at 7:30 we should be at the hotel. However, we open the floor to debates. Otherwise, we should proceed like General de Gaulle, who in his press conferences would always say, "Now I take the question that has never been asked." Chair, if there are no questions or nobody would like to ask anything, I would like to make 2 remarks. The first, for Mr. Jankowski, and for Mr. Bezemek. Mr. Bezemek spoke about the agreement between the EU and Turkey from 2016. And on talking about that, the conclusion was that this was a violation of international law in the field of refugees. And I agree. And not because Turkey did not sign and ratify the 1951 Geneva Convention, but in fact, Turkey expressed reserves based on its geographical position, and other countries had the same position. However, other countries in the end gave up the reserves, while Turkey is still reserved in its position. So the Geneva Convention does not apply to Turkey when refugees come from other geographical areas but Europe. But Turkey, under international pressure, was obliged to adopt in 2014 a specific law, a law providing for temporary asylum. And what I want to say is that in such a case, this is not something which is based on the rules and the principles, but is based on practical experience. All NGOs, important NGOs such as Amnesty International, say that in Turkey there are violations of the refugees' right. Not only with respect to their refoulement or rejection, but also with respect to the refugees inside Turkey, between one region and another of Turkey. And I do agree that this right is violated there. But let's be realistic. In Greece, many NGOs, and also inside the governing parties, there have been very critical opinions about the agreement between the EU and Turkey. But the minister that is charged with refugees, a technocrat, he is actually the president of Médecins Sans Frontières. He said, okay, what do you suggest if we don't accept this agreement? What is the alternative? He said something like that 4 or 5 days ago, and there was no answer given to this minister charged with migration. So we can see that there is a difference between the principles of the law and the political society, so to speak. On the other hand, regarding what Mr. Jakovsky just presented, you spoke about ancient Greece. Sorry, Mr. Bezemek did. I'm sorry. So you spoke about the notion of a refugee in ancient Greece. And you also mentioned those whom the Greeks called barbarians. And I agree with a certain nuance. They said that aliens that participated in their own culture were not barbarians. But I would also like to point out that in the majority of the European countries, the vision was quite similar when it came to the difference between aliens and barbarians. The Indo-Aryans, for instance, they made the difference between the Indo-European language Sanskrit with one word only for alien, and that was barbarian. So, in the ancient world, in the old world of antiquity, this was a common approach that was found everywhere. Thank you. Are there any other questions or comments, perhaps?
To ask one question. I'm of those who think that the content of the so-called agreement between the EU and Turkey is contrary to certainly a number of legal principles. But the question is, who has violated law? I don't want to answer it, but it creates quite a series of interrogations which the court will have to address, because we don't even know if there is an agreement. Et ça m'amène à faire une remarque plus générale.
And a more general remark. One of the difficulties, and allow me, because I'm a bit older than many of you present here, and if we analyze the case law of the European Court of Human Rights especially, we find there some procedural elements, formal elements, that influence the answers of the court. As many have already mentioned, the case law is not so clear and not so consistent. Many times we keep saying, yes, but what was the question asked to the court? The decisions of the court refer to a preliminary question, renvoi préjudiciel. So we should know what the question was, what the national judge asked. Suppose the judge rejected a certain case, and we need to know what was the court decision, the national court decision based on. And that's how we may see that the case law of the European Court on asylum and subsidiary protection varies. This kind of decisions are very fragmented, if I may call them so. Unfortunately, we don't have all the elements that would enable us to have an idea on the mix of issues that the European Court had to decide on.
Eine kurze Frage an den Professor Bezemek. Die Idee des Weltbürgers.
Short question to Professor Bezemek. Speaking about this universal citizen, can it be conciliated with the concept of state, of a state based on rights and duties, common rights and duties, or do you think it requires other forms of organization? And if so, what is the type of organization which is necessary?
Verschiedenen Sprecher das Wort wieder zu geben.
Okay, I give the floor to Mr. Bezemek, and then we will take the answers given by the other members of the panel. Thank you. First of all, allow me to answer the question asked by Mr. Jakovsky. We look very much the same, it seems. That is why sometimes there was confusion between our names. Well, thank you. Thank you for your observation. It adds a lot to what I said. It confirms that the inclusive function of the language is a ubiquitous phenomenon in society, and that if we go beyond facts, the facts that separate an individual from the group, we come to the moment of social disentanglement, and at that moment the language is a betrayal factor. We recognize the others based on the models that are familiar to us, and we translate that in a social situation which is closer or further from us. That is why the discussion about the term barbarian and what it means, it is remarkable that it means nothing else than someone who said barbarous. So that means that the barbarian is hard to understand, incomprehensible, and because of that, a barbarian will be excluded on account of the language spoken. Speaking of what Robert said, if we were reading now Immanuel Kant, I have no problem with the conciliation of the two notions. But speaking about this permanent state of peace, well, it all stems in the national state. And we are speaking also about a visiting right. And this visiting right can be accepted. Well, you see, I can be a visitor. I can be a guest where I'm not home, where I don't feel home. But if we expand this right, then we verge on an international claim where at the expense of some elements that are featured of the state. If we speak about the rights of universal citizens, we may also speak about some moral claims to be formulated there. And that will take us to a moment where we see nation eroded as well as citizenship eroding. And citizen actually translates the state of belonging to a state. So it depends on whether we see this notion like a wider notion or a wider notion. But we can make a compromise between whatever is linked to a state and whatever is linked to the protection of dignity, love and protection for our fellow people, and so on. Things that stem on our own vision of mankind. This is a compromise. But this compromise brings us to several issues that we will discuss today, tomorrow, and the day after. It's clear we will cast a light on these things.
First of all, responding to this Turkey law case, it's not only the practice, because the law is, like you said, temporary measure. And European Court of Human Rights says no temporary measures when applying or when examining the case under Article 3 of the Convention. So very high standards developed as a principle, and in practice lots of temporary measures taken and due to political reasons. So not only because of practice, but also because of law, there is a violation of the principles. Who has violated the law? Turkey, maybe, Greece, maybe, but other countries who could not or did not take over the refugees in a, let's say, solidarity mechanism, they cannot be told to violate the law. So what's the effect? We have very high principles developed and no alternative, no way to apply to them. So what's the idea? Because the EU, Turkey, the idea is to result, to make a freezing effect. I think that the governments know they violate the principles, but they wish to make this freezing effect. Maybe in some years the European Court of Human Rights decides on violation, but we agree, we are ready for that. It's like with Al-Qaeda prisons in Poland. Everyone knew that that it's a violation of European Convention, but the governments were ready to accept it. Or now adopting some unconstitutional statutes in Poland, the government ready that in some years maybe somebody questions this law. In my opinion, it leads to erosion of legality rule, the rule of law. We shouldn't do it. This was my question. If we should keep up to those high standards, or should we, let's say, decrease the standards maybe by signing a new convention, new protocol? This is the question I cannot answer. But keeping up in law, in books, to those high standards and in practice violating them for many years really, in my opinion, leads to erosion of the other principles of constitutional law, our basic principles.
En premier lieu, merci pour ne pas avoir de questions.
În primul rând, thank you for not asking me questions. I have two remarks. Of course, the debate on the idealistic approach or the practical approach, and speaking about let's make the standards evolve. All this discussion is very good, very right. It's good to have the standards that we can implement. And we should adopt practical and things that are realistic in relation to the practice of any state. And the discussion is open on that. In the same time, I believe that this idea of accepting the fact that we are faced with a violation of the law, well, it's something I do understand because I work inside the government. But how shall I put it in plain words? realistically speaking, this is something that we should all do. I mean, ask the questions of the level of international standards. It's the right time to ask this question. However, implementation is part of the text of the convention. And when we speak about litigation caused by the respect of human rights, well, suppose the court in Strasbourg finds some violation of a text or another. But it is difficult to put into practice something that the court decided. These texts are hard to implement in a way that rights and freedoms are protected. I would like to try to give an answer to a comment you just made. I do understand the difficulty of the position of the European Court of Human Rights, but I think that in the same time, the court could benchmark various decisions in this preliminary requests sent by various states. So give the same decision. Suppose the question is, aliens that have a gay orientation, are they a social group in the sense of Article 10.1 from the directive? I think this is a question which is strictly formulated, but the court could answer in a more elaborate way to prevent additional questions in the future, in this renvoi prévisionnel, because otherwise the court should provide us with lengthy lists saying, if you have this question, please refer to A, B, C, D, and the long list follows. Of course, we shouldn't ask every time the court to check whether one interpretation or another of the text is correct. Thank you, Chair.
I would like to thank the chairperson. In my capacity as president of SIPE, there is another important issue related to the ECHR case law related to the asylum. The court's decisions are often politically biased. And that is because decisions are different. Coming back to the case where Greece was sentenced, the state has the obligation to provide minimum assistance to aliens. In the case of Greece, in this crisis situation, Greek citizens addressed the state and it disregarded all principles, including the proportionality principle, and stated that national authorities know better the economic situation. Here we have two cases referring to people, aliens or citizens of a specific country. And the court uses different principles. For the aliens' protection, it uses very strong principles, but for the protection of a country's citizens, these principles are implemented from a minimalistic perspective. The court makes decisions that are strongly politically biased. The European Committee for Social Rights has issued a notification against Greece, but the court disregarded it. The International Labour Organization did the same thing, but the comparative right was also disregarded. In its decision, the court stated that the national state is the one that best knows the economic situation. This workshop has several aspects. On the one hand, it's an introductory time for the Congress, so I think it's been very useful. You have heard plenty of interesting things, and they all lead to the issues that will be tackled in the following 2 days. The second objective on our agenda today is the possibility to set up a dialogue between generations, between youngsters and elder people. So we are opening now this dialogue, and we will certainly go on with this dialogue. I hope that today's speakers will also intervene tomorrow. Now I would like to ask Mrs. Tănăsescu to tell us if she has any further practical comments to add. Personally, I would like to thank you for your attention. My name is Simina Tănăsescu. Given that the meeting of the Executive Committee will no longer be held today, but tomorrow, the participants can now enjoy some free time. At 7:45, Lucia Leontie, who is a PhD from the Republic of Moldova, and she's studying now in Paris. She has scholarship granted by UF. She will wait for you in the hotel lobby in order to accompany you to the restaurant. It's a 3-minute walk to the restaurant. So first you go to Novotel, and then you will go to a restaurant, which is on the terrace of a close-by hotel. Thank you once again. As for our agenda, we will resume the works tomorrow morning. The registration will be between 9 and 9:30. For those ones who haven't registered yet, at 9:30 we will officially open the Congress, and I would also like to thank the interpreters for their work.